Governor Cicchetti.
Thank you, President Majumdar, and I appreciate being able to leapfrog here a little bit. We do have two guests, former Governor Michael Cherry and Professor Hugh Spitzer, who are here to report back on the committee's Alternatives to Mandatory Malpractice Insurance Committee. Just to give a quick background before I turn it over to folks, you'll find the materials at 394, late materials 144, and late materials 12. So I encourage all of you to take a look at those. You'll recall that we met with the Board of Governors last August, the last meeting in August, had a proposal, had a very robust, healthy discussion. The committee then met and discussed the concerns that we heard. And while we think that there are merits to two of them, that we want to encourage the Board of Governors to go along with the recommendation. We did make some concessions in light of the concerns that we heard, and I'm going to turn it over to Professor Spitzer and former Governor Cherry to discuss the committee's actions and thoughts and discussion topics. So with that, I turn it over to our guest speakers.
Great. Maybe I'll start. I'm Hugh Spitzer. I teach at the UW Law School, and I'm a member of this committee. As you'll recall, we had made recommendations on increased disclosure concerning malpractice insurance that lawyers have. And there were some elements that board members last month were concerned about. Some board members asked whether the level of the insurance for purposes of disclosure might be too high. We went back and talked about that in a lot of detail, and we're still recommending the $250,000, $500,000 level, given the cost of resolving claims and the fact that the vast majority of malpractice policies are so-called wasting policies, where a significant amount of the insurance is used defending the claims. However, on a couple of other things, members of the board were concerned about the breadth of what we had recommended, particularly the suggested requirement of disclosure of lack of adequate or lack of insurance on letterhead, on all letterhead, and on all emails, because the correspondence in letterhead goes to people other than clients. So the issue was whether this disclosure should go broader than clients or just be focused at clients and possible clients. And some of the comments that were received from members of the public were concerned. They thought maybe we were shaming people into getting insurance. So after discussion, the committee agreed that the scope should be narrowed. And so the revised draft that is before you applies only to written communications to clients. There still would be a requirement that a client be informed, have informed, and then provided informed consent if she has a lawyer who doesn't carry the minimum levels of insurance. You'd also have notice in solicitation of new clients and on a lawyer's website, which actively functions as a solicitation mechanism. So that's the key change, is that we are really suggesting narrowing the scope of this requirement to client and new client, possible client directed materials. There was also a discussion as to whether the records retention provision should be 6 years, which we had suggested. We kicked this around, and some requirements for other reasons of law and regulation are 10 years and some are fewer. And we just decided 6 is a good balance, and so we stuck with it. I think that's all I'll say. And maybe Michael or Governor Cicchetti has additional comments.
I would just like to say that I did reach out to several insurance companies as well as individuals who underwrite insurance brokers. And the 80% of the policies was the number I heard are wasting policies. And so that's why we felt that we didn't need to really kind of address that. It's not that we didn't want to, it's that it really doesn't apply. And with that, I think I just want to move to the questions so that we can keep the agenda moving.
Let me add just one more thing for Governor Cherry and Professor Spitzer, and maybe you can answer this question because I think it will come up. The one question that we should be prepared to answer, and maybe you can, is why, if we're getting informed consent from the clients, do we have to continue to provide notice to them in correspondence? If you could just address that issue, I'd appreciate it.
Former Governor Cherry, do you want to try that one?
Part of the concern, I think, is that it's and perhaps Doug Endy will comment on this as well. Part of the problem, as I see it, is that we struggle as attorneys with when this relationship with our clients is created. And it's created in the impression of the client, not the attorney. And therefore, I just felt that it's necessary that there be sort of this continuum of presenting this knowledge to the client. And that's really all we're trying to strive for, is to make sure that people worry about when does the public understand how we hire a lawyer? Does the public understand this process? And so we're just trying to make sure that there's coverage so that the public, the client, the non-lawyer understands what's going on with this.
Thank you. And I just want to, before we turn it over for questions, I just want to remind folks or alert them that Professor Spitzer has other obligations at 12:30 that he's going to have to attend to. So if we can make the questions or comments short and brief, I would appreciate that. So with that, President Majumdar will open up to questions.
With that, we have public comment starting in 206, ending in 100 phone number. Then we'll go to Governor Peterson, then Governor Grabicki, then Governor Williams-Ruth. There is a trick to unmuting phones. I believe it is *9.
*6 to unmute.
There we go. *6.
Hello.
There you go. Go proceed, please.
Thank you. My name is Bob Wayne. My practice concentrates in the area of legal malpractice, and I strongly support this measure from a consumer protection point of view, so clients have knowledge and can make a decision about whether to hire a lawyer. However, I think there are three areas in which this rule has some defects that ought to be addressed. In paragraph C1, it requires notification at the time that one commences representation of a client. For those who have ongoing or continual clients, that would mean that they do not have to give such a notice. This should really be addressed to at the time of commencing representation of a client or a new matter for a client, so that the client can get notice even if they are a long-time existing client. The next comment I would make is about paragraph 3, and it goes to the question of whether there needs to be communication in each communication by the lawyer to the client. It seems to me that the comment made earlier that once you get informed consent, that's a little bit of overkill. And I would suggest that that not be the case, that it should be in the solicitation and formation phases, not the continuing representation. With one comment to that. I think there should be a requirement that the notification of the client go out at least once annually. And the reason for that is that our claims made policies are an annual renewal. And unless the attorney has coverage each year, the fact that they had coverage at the beginning of the representation would have no benefit. They have to have it each year. There should be a requirement of annual. The last comment is about comment number 10 on page 3. And this goes to the notification on the website. Unfortunately, the language that is used here, clear and conspicuous notice, means disclosure in a font type used to convey the majority of the content in the written client communication. That's the wrong reference. We're talking about the letters they sent. What we should be referring to is the font size that is used on the website page. And we should require that the notification not be buried on 15 click downs on the page, but be in the first half of the first page, and that it be in a typeface equivalent to the largest typeface used on that page. With those suggestions, I think the rule would be improved. I strongly suggest it because consumers should be informed of this so they can decide whether to hire a lawyer who doesn't seem to have the regard for them to protect their assets in case of negligence. Thank you.
Governor Peterson?
Yeah, first of all, great job. And conceptually, I like what we're trying to do here. I just had a couple questions and comments. The first question was, over the last 10 years, how many unresolved claims, that weren't resolved, went over $100,000?
I don't have that data.
Yeah, I don't either. I do not recall it from the earlier reports. Unresolved over 100K.
Okay.
Oh no.
So we're
we know that 80%. No, sorry, in the 90s percent are settled under 100, and in the 80s under 250-500. Our concerns mainly the wasting aspect of the policy.
And what does that cover? Is that Washington State?
Let's see. That is basically Washington. I don't have the report of the earlier committee and task force in front of me, but the vast majority, I'm guessing like 95% of claims are settled at under 250 and 80% under 100. So most are small, fairly small. There's no question about it.
It looks like Governor Cherry maybe.
I'm trying to look it up. I apologize.
Yeah, I mean, if we don't know the answer to that question, I would suggest we do 100, 300, and I think it actually, helps what you're trying to do if we go down to that level, because, if that allows 100 more attorneys to purchase an insurance because it's a little bit cheaper, we're actually doing a service to the public. So, I'd encourage, if we don't know the answer to that, we would go to the lower limits because it helps exactly what you're trying to get at. And
Governor Peterson, one thing to note is that there wasn't a substantial. The difference in rate between the two was very small. There seems to be this threshold once you cross it, but I know that we did look at that, and the difference, the delta in cost, wasn't that great.
So, what was the delta?
We're talking about a couple of $100.
Yeah, I mean, I think a couple $100 for, because we have to kind of assume that a lot of these attorneys that don't have insurance are probably those attorneys that simply can't afford it, right? Because they're putting their personal assets at risk by not having insurance. Well, a couple $100 for somebody that can't afford insurance, I do think could make a difference. And if we don't know, don't have any data as to, 100 doesn't cover or not cover, I think we want to encourage as many people as possible to purchase the insurance.
I might also add, since there's a lull in terms of Bob Wayne's suggestions, the suggestion in comment 10 to add, say, the words or website page after written client communication is an excellent suggestion and should be adopted in the in an amended recommendation. The other two issues are a little more complicated. The idea of notifying once a year, not a bad idea at all. We thought that the coverage that client communications continue to have the notice on an ongoing basis would cover that. But that is it is a creative idea.
Governor Peterson, while former Governor Cherry looks up the information, were you done with your question?
I am, thank you.
Governor Grabicki?
There you go.
Rajiv, maybe it'd be appropriate to let Hugh and company respond to the 3 points that were made by the caller before we do anything else.
Oh, I apologize. Of course, that would be very appropriate. If they have any response?
Well, let's see. That's sort of what I was. That was Bob Wayne's comment. Yeah. So, first suggestion was that we should have notice for each new matter, and we considered that, and the consensus was that if we have continuing notice in correspondence to a client, then we don't, so that's always at the little bottom as an automatic squib under the signature or someplace like that, then we don't need to have a new notice and consent with each new matter. If you didn't have the requirement and on an ongoing basis in continuing correspondence with the client, then that should be a requirement that it should be, you should get client consent for each new matter, and that there be notice and consent on an annual basis. I think those were the two, and the third one had to do with adding our website page in comment 10, which is an excellent suggestion.
Governor Grabicki.
Thank you. Would somebody remind me what the malpractice limits requirement is for triple LTs?
Yes, 1 second.
Thank you, Chief Regulatory Officer Garcia.
While Hanad is looking that up, I can provide some information from the task force report about resolution of claims if you would like to hear it.
We would love to hear it, Chief Disciplinary Counsel Ende.
Okay, this is from, this is directly out of the task force report. Nationally, 89.1% of malpractice claims are resolved for less than $100,000, including claims payments and expenses. 95.2% of malpractice claims are resolved for less than $250,000. ALPS, which is the WSBA endorsed professional liability insurance provider, reports that based on its experience over the past 10 years, about half of all its claims are resolved without payment, and 97% of its closed claims were resolved for less than $250,000, including defense costs. According to ALPS in Washington, for all claims, its average loss payment was $60,548, and average loss expense to defend those claims was $20,406. Where payments were made by ALPS, its average loss payment was $119,856, and average loss expenses were about $40,454. And also, I believe the triple LT requirement, and Hanada can correct me if I'm wrong, is 100, 300.
Yes, that's correct. And for limited practice officers, it's a different requirement. It's errors and omissions policy, and that is 100. And or another way to show financial responsibilities, audit financial statements in the amount of $200,000.
Thank you. I served on the original mandatory malpractice task force, and I served on this committee. I think that the proposal is well thought out. It's been worked and reworked for several years now. And I would urge that we adopt it and forward it to the Supreme Court. I would remind everybody that the Supreme Court has before it a proposal for not disclosure, but mandatory malpractice insurance, and that it's a very persuasive proposal. And that the Supreme Court knows that both neighboring states, Idaho and Oregon, have mandatory insurance requirements. So if we reject this, I think you can have some confidence that the Supreme Court is going to do something, and the Supreme Court will probably do more than this. If you don't want to have mandatory malpractice insurance as a rule handed down by the Supreme Court, you should support this as a defensive measure. And with that, I will move that we recommend the proposed rule to the court.
You have a motion put on the table by Governor Grabicki.
I second.
You have a second from Governor Schicchetti. Now I'll move on to more comment. Governor Williams-Ruth.
Thank you, Mr. President. As presented, I cannot support this proposal. I will disclose, I come from a family that values insurance almost above anything else. Homeowners insurance, car insurance, health insurance. I've never been not insured in my life, even when I had no money, because of my family's upbringing that you need it right when you don't have it. So I am well insured. But I also spent many, many years as an insurance coverage attorney and in this state. And, you know, I heard the comments made by the presenters that, well, 80% of the policies are wasting, so let's not even go there. But 20% aren't. And it's up to the person who purchases it. I, again, have purchased a non-wasting policy because, again, as a coverage attorney, I saw what happens when people run out and the decisions that start being made in litigation when, oops, hey, we're running out of money to indemnify. But really where I have the greatest concern is in paragraph, so I'm looking at page 398 of the materials and number 3, where it says a lawyer not covered by lawyer professional liability insurance shall provide clear and conspicuous notice of the fact on each written communication with a client or potential client. I just, once you have advised the client and you've received that informed consent and they've initialed, I don't understand the virtue and value, even after future President Schicchetti tried to explain, I still don't see the virtue and value of having that be repeated over and over again. So if I write to my client 7 times in a week, each letter has to include a thing, again, not going to because it's not me, but that a person would have to say, oh, by the way, P.S., I'm still not insured by professional malpractice. You know, I will say that I did actually take a public poll 2 weeks ago on my public Facebook page where I have over 1,500 people, and I asked for a simple yes or no. Would you want to know if your attorney was not covered by malpractice? And everybody but one person said yes, they would want to know. So I would support a proposal for mandatory malpractice, but I think that we need to have something that is less geared towards trying to shoehorn compliance, is how I see it. I really just can't wrap my mind around the concept of why you'd have to continuously write to someone and have a PS footnote that says, by the way, still not insured, if they've already made that choice to work with somebody who is not. Thank you.
Governor Knight.
Thank you, President Majumdar. I move to amend the motion to remove from the proposal paragraph C3 and comment 10 in their entirety, and to change the coverage limits found in paragraph C5 and C2I from 250-500 to 100-300.
Second.
I have a motion on the table, a motion to amend on the table from Governor Knight, which has been seconded by Governor Higginson. Governor Knight, in layman's terms, could you explain the first part of your proposal?
Absolutely. Paragraph C3 and comment 10 address the continuing requirement to provide notice to your clients in written communication on the website. They do not address the informed consent confirmed in writing. Obtaining conformed consent confirmed in writing is enough. That is the standard for a potential waivable conflict of interest. Once a client has waived a conflict of interest, there's no requirement that we continue to put that in every email. To impose that requirement for mandatory malpractice insurance is to shame and embarrass the lawyer into obtaining insurance. It's a scarlet letter requirement, and it's clear that the only point of that requirement is to get lawyers to buy malpractice insurance. The goal of this board should not and should never be to get lawyers to buy malpractice insurance. That is doing the bidding of ALPS and doing the bidding of the insurance companies. That's not our role. The goal is to protect the public. Let's not forget that insurance protects the insured. It doesn't extinguish a claim. A lawyer could choose to be self-insured. I'm confident that I could collect a $100,000 judgment from many lawyers. It's not a significant amount of money in the big picture. If lawyers choose not to have malpractice insurance, they can make that choice. And I think it's important that the client knows. They already know because they have constructive notice that's reported on the WSBA's website. I do support this motion's efforts to have actual notice confirmed in writing with the client. And so I think that's good. But anything beyond that is simply designed to embarrass the lawyer, and it doesn't advance the real goals that we should have. And so I think that's wrong. Our goals as a board should not be to embarrass lawyers. I wonder about what the statistics are of those lawyers who choose not to have malpractice insurance. I am confident that there is a strong correlation between traditionally underrepresented lawyers and lawyers who choose not to have malpractice insurance. We're going to make it harder on the people that it's hardest for. The people that have the hardest time paying for overhead are now going to have a harder time. That's not fair. That's not right. That's not our job. If a client wants to hire a lawyer at a lower hourly rate because that lawyer chooses to keep overhead lower, the client should have that option. They should just know that their lawyer is self-insured and that they're going to have to collect from that lawyer's personal assets as opposed to an insurance policy. I also want to speak to so paragraph 3 and comment 10, those are about the continuing requirement. It's just unnecessary and wrong. The coverage limits, the data is clear. 89.1% of claims are resolved for less than $100,000. There's no reason the limit needs to be higher than $100,000. In the event the damages were higher and someone had a $100,000 policy, their judgment is not capped at $100,000. It's just that the personal assets of the lawyer are on the line. And so when buying insurance, the analysis is, how much do I want to protect my personal assets? And, because I don't want my house and car and boat to be, garnished and sold. So let the lawyer make that decision. It doesn't extinguish the claim. 100-300 already covers virtually every claim. And the very small percentage of claims that it doesn't cover, the client could still collect from that lawyer. I suspect that there's also a correlation between the value of claims and the lawyers that have malpractice insurance or don't have malpractice insurance. I suspect that the lawyers doing multi-billion-dollar mergers and acquisitions all have professional liability insurance. I suspect that those lawyers who choose not to have professional liability insurance may tend to have cases that correlate with damages that are going to be sufficiently paid under a 100-300 policy. I don't see a reason to depart from the limits set by Idaho. I don't see a reason to have them so much higher than the average claim. And so those are the reasons that I move to amend this motion in that way.
Hey, Russell, don't you also have to address the issue of matter then? Every new matter they have to disclose and get an acknowledgement? Well,
so I think obtaining informed consent confirmed in writing is sufficient under the remainder of the rule. Paragraph C3 is a paragraph that governs the continued disclosure. So I'm not sure I understand what you're asking.
The reason that we had the continued disclosure was so that we didn't have to deal with the issue of if the client if the attorney takes on a new matter, there doesn't have to be another disclosure because it's a continuing disclosure. If you're going to do it your way, don't you need to have some language in there that says if the attorney then later undertakes a new matter, they've got to do the disclosure and consent again?
I don't know that the disclosure and consent is necessary again. I think one analogy here is a contract for legal services. I do think that a lawyer can retain a client can retain a lawyer under a contract for legal services for matter one, and then if the lawyer represents that client in matter two, the same contract would govern those terms. In the case that you're describing, the client would already know that their lawyer doesn't have malpractice insurance, and they would be voluntarily choosing to hire that lawyer again. So I think the goals are met. I guess I don't inherently have a problem with it being addressed at each matter. To some extent, there is some gray area about which is a new matter. I think in litigation, it's very clear if you are bringing a different lawsuit, but the client that's calling for advice on, renting out their single family home to tenants or something like that, is every single phone call a new matter? I don't think so. So I think informed consent confirmed in writing is sufficient. They already know you don't have malpractice insurance, and they still know that when they retain you for a second matter.
Okay, so it is 12:20. I'm going to stop our conversation at 12:30, and we're going to pick up again at 1 o'clock. I'm letting them know for the next speakers that I talk to be as concise as possible. No tripods of jury closing lengthy arguments. Or if you could, be respectful of everyone's time. Get your perspective on the table, not be duplicative. I'm going to let the presenters respond to some of the stuff that's been talked about to make sure we're all on the same page, and then I'll move on to past President Piggott. So,
President Majumdar, I would ask that you refer to Professor Spitzer real quick. He does have a response.
Professor Spitzer.
My suggestion was that if the governors decide to pull subsection 3, which would cause 4 and 5 to be renumbered, of course, then you could, if you wanted to cover each new matter, in C1, which is at the beginning, it could say that a lawyer not covered by the whatever the minimum levels are shall before or at the time of commencing representation of a client in a matter. You just add those 3 words.
Former Governor Cherry. Are you just in the regular queue?
I'm just a little bit confused about Mr. Wayne made some suggestions which were, I think, worthy of consideration. I think Professor Spitzer noted some of those. So is the motion to incorporate those things which Mr. Wayne suggested as well, or are we just sticking with what was in the materials?
Former Governor Cherry, my motion to amend is to remove paragraphs C3 and comment 10 in their entirety. I think that partially addresses the commenters' concerns, although I acknowledge that it's different.
Thank you, Governor Knight.
Okay. Past President Pickett.
I'll try to be quick. So my take on this is a great opportunity for this board to take this by the reins and control their own destiny. As PJ already pointed out, there's something much more strict and much more burdensome at work. And I would encourage, whether it be Russell's amendments or something else, that you do something today rather than have it done to you. This has started way back in the 80s when our recently departed former President Bill Gates Sr. tried to get this through. He put it through to the membership and it failed miserably, not surprisingly. Then a guy named Bill Pickett tried to put it to the board in Yakima, and he failed miserably. This is an opportunity for a guy named Rajiv Majumdar to wrap up his presidency with a success. And it's a success in that it's a step in the right direction. And I hear everything Russell says in terms of protecting lawyers, and I think that's part of what we want to be cognizant of here is not harming lawyers. The other thing, though, is we do want to protect the public. And in the last 5 years, this would be one of the most monumentous efforts, albeit a start, that says this to the public from this board: we care about you. We care about you, and we are actually going to elevate your interests above our own, not knowing how it's all going to work out, but we're going to do it anyway. So I would encourage this board to do something today so that it does.
President Pickett.
Thank you. Appreciate
Former
it.
Governor Cherry? Or was your question?
I'm sorry, I should have lowered my hand.
Thanks. Governor Higginson?
Well, Governor Knight was so eloquent. I would only like to echo what he had to say. I think it's well thought out. I do want to remind everyone that the statistics seem very compelling, that the vast majority of claims would be settled for less than $100,000. I think that that's important. I also echo the fact that the proposal on the table to amend will not harm the public, and it may, in fact, by lowering the insurance that we're encouraging people to get, allow more people the ability to do that as opposed to making a disclosure. I think that the proposal to amend is very well thought out. I generally don't like this alternative at all to mandatory malpractice insurance. We rejected it last year, the general concept. I understand the court has the discretion to do as it wishes. So I'm going to just vote in favor of this proposal as amended, and think that it does serve the members and also protects the public's interest.
Thank you. Mr. Bob Wayne?
Thank you, Mr. President. The one concern I have about the amendment is that there's a little bit of throwing the baby out with the bathwater. And that is that although I agree that we should not require every communication to contain this language, and I agree with that part of the amendment, I very strongly believe that it should be required to be on the website. And the reason is that's where the public shops. That's where they decide who to call, who to contact, and they should know that they're calling an uninsured lawyer. And the amendment gets rid entirely of the requirements under C3 and comment 10 for the website. So please keep that in mind. I would prefer if the amendment was offered alternatively and that the board could consider each of those parts separately. Of course, I'm not a member. I can't make that suggestion other than persuasively. As to the point made by Hugh Spitzer, who I very greatly respect and is an authority on this area, the language in paragraph 1 regarding commencing representation of a client, he suggested in a matter. Again, the concern is if I have a client for 5 years' time, I am not commencing representation of that client. That client's existing and would never get a notification under the language drafted. However, if it did require that clients who ask me to do a new matter, that I have to give them the notice, or that I have to give the notice at least annually, then for sure the client would get the word and would be able to make a decision. You'd be surprised at the number of people out there who don't know this. And even though our bar website contains a disclosure form, I would suggest that a small percentage of lawyers know what's on the lawyer directory, and virtually no one in the public goes there to look. Thank you.
Thank you. With 2 minutes left, we have Chief Disciplinary Officer Doug Ende.
Thank you, President Majumdar. If paragraph C3 comes out, I think that the issue of the new matter is a significant one. And I appreciate Mr. Wayne's comments in that regard. I think I part company slightly with you on how it ought to be drafted, which is why it's always problematic to draft live at a BOG meeting on the fly. But that being said, I do have language that I think might work, and the language would be at the end of the first clause before the comma, at the time of commencing representation of a client or initiating a new matter for an existing client.
A helpful suggestion. Governor Knight, would you like to respond to that suggestion?
I understand the need. I think the question is, what constitutes a matter? And I think it's clear in some contexts, in litigation, it's that lawsuit. In other contexts, I think it's less clear. And so, I don't know if that term would need to be defined. I generally continue to believe that once a client has given informed consent, that is sufficient. They, of course, continue to have constructive notice by simply going to the WSBA's website and checking whether their lawyer has malpractice insurance. They could, of course, ask their lawyer if they have malpractice insurance, and the lawyer would have to be honest about it, obviously. Perhaps what the bar can do is a greater, public information campaign about you can look up your lawyer on WSBA. There are less restrictive, less embarrassing, less shaming ways to accomplish this. So I understand the comments about the adding in the new matter, and I think there's a great value to those comments. So perhaps we need to have a further discussion about it.
In fact, I am going to pause our morning session. We will take this matter back up at 1 o'clock. Just to let people know on the webcast, we are going to be resetting the webcast session, so you will have to log back on. It won't affect our Zoom session if you are logged in by Zoom, but I will see you all at 1 o'clock.
President Majumdar, Professor Spitzer is not going to be with us.
No, he will not be with us, but we will still resume this at 1 o'clock.
We do want to thank him for all his hard work on this.
Yeah. Thank you very much.
Thank you, Professor.